Book 1, Articles 1 to 99 RPC exclude the provisions on civil liability. Fundamental principles. Definition of criminal law. Principles of public international law exempt certain individuals from the generality characteristics of criminal law. Who among the following are not exempt from the generality rule? 2011 bar. Ministers resident, commercial attaché of a foreign country, ambassador, chief of mission. Answer: letter B, commercial attaché of a foreign country. The maxim nullum crimen nulla pena sine lege means that crime is a product of the law. When a penal law is absolutely repealed such that the offense is decriminalized, a pending case charging the accused of the repealed crime is to be dismissed without any precondition. It is a matter of judicial knowledge that certain individuals will kill others or commit serious offenses for no reason at all. For this reason, a lack of motive can result in conviction where the crime and the accused part in it are shown. Motive is generally immaterial in determining criminal liability except when the evidence of guilt of the accused is circumstantial. Y inflicted serious injuries on X because of delay in providing medical treatment to X, he died. Is Y criminally liable for the death of X? Yes, because the delay did not break the causal connection between Y's felonious act and the injuries sustained by X. X inflicted violent kicks on vital parts of E's body. E nevertheless was able to flee for fear of his life. Refusing to undergo treatment for his injuries, E died 3 days later. Is X liable for E's death? Yes, since it was a natural result of the injuries X inflicted to E. What court has jurisdiction when an Indonesian crew murders the Filipino captain on board a vessel of Russian registry while the vessel is anchored outside breakwaters of the Manila Bay? The Philippine court. Tonito, an 8-year-old boy, was watching a free concert at the Luneta Park with his father Tony. The child stood on a chair to be able to see the performers on the stage. Juanito, a 10-year-old boy who was also watching the concert, could not see much of the performance on the stage because Tonito was blocking his line of sight by standing on the chair. Using his elbow, Juanito strongly shoved Tonito to get a good view of the stage. The shove caused Tonito to fall to the ground. Seeing this, Tony struck Juanito on the head with his hand and caused the boy to fall and to hit his head on a chair. Tony also wanted to strangle Juanito, but the latter's aunt prevented him from doing so. Juanito sustained a lacerated wound on the head that required medical attendance for 10 days. Tony was charged with child abuse in violation of Section 10, letter A, in relation to Section 3B, number 2 of RA number 7610, Child Abuse Law, for allegedly doing an act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being. In this defense, Tony contended that he had no intention to maltreat Juanito, much less to degrade his intrinsic worth and dignity as a human being. Distinguish crimes mala inse from crimes mala prohibita. Suggested answer. Mala inse and mala prohibita are distinguished as follows. Mala inse are inherently wrong or immoral, while mala prohibita are not inherently wrong. They are only wrong because they are prohibited by law. In mala inse, good faith or lack of criminal intent is a defense, while in mala prohibita, good faith is not a defense. Mortifying circumstances can be appreciated in mala inse. These circumstances cannot be appreciated in mala prohibita unless the special law that punishes them adopt technical nomenclature of the penalties of the revised penal code. Mala inse are punishable under the revised penal code or special laws where the acts punishable therein are wrong by nature. Mala prohibita are punishable under special laws. Choose from the list below the correct principle in considering motive. If the evidence is merely circumstantial, proof of motive is essential. Generally, proof of motive is not necessary to pin a crime on the accused if the commission of the crime has been proven and the evidence of identification is convincing. Letter C. Motive is important to ascertain the truth between two antagonistic theories. Letter D. Motive is relevant if the identity of the accused is uncertain. Letter E. All of the above are correct. When are light felonies punishable? Light felonies are punishable only when consummated, with the exception of those committed against persons or property. Construction of penal laws. Doctrine of pro reo. What is the doctrine of pro reo? How does it relate to Article 48 of the Revised Penal Code? Suggested answer. The doctrine of pro reo advocates that penal laws and laws penal in nature are to be construed and applied in a way lenient or liberal to the offender, consonant to and consistent with the constitutional guarantee that an accused shall be presumed innocent until his guilt is established beyond reasonable doubt. Following the pro reo doctrine, under Article 48 of the Revised Penal Code, crimes are complexed and punished with a single penalty, example that prescribed for the most serious crime and to be imposed in its maximum period. The rationale being that the accused who commits two crimes with single criminal impulse demonstrate lesser perversity than when the crimes are committed by different acts and several criminal resolutions. People versus Comadre. However, Article 48 shall be applied only when it would bring about the imposition of a penalty lesser than the penalties imposable for all the component crimes if prosecuted separately instead of being complexed. The acquittal of an accused shall bar the civil action arising from the crime where the judgment of acquittal holds that 2013 bar the accused did not commit the act imputed to him. Subsidiary liability may be imposed on the following except parents of minors who act with discernment in committing crimes. 2013. Luis was sentenced to prison mayor and to pay a fine of 50,000 with subsidiary imprisonment in case of insolvency. Is the sentence correct? No, because subsidiary imprisonment is applicable only when the penalty imposed is prison correctional or below. The death of the accused extinguishes his criminal liability, but civil liability is not extinguished. 2013. When the death of the accused occurred after final judgment. Criminal law, fundamental principles, absence of corpus delicti. Dang was a beauty queen in a university. Job, a rich classmate, was so enamored with her that he persistently wooed and pursued her. Dang, being in love with another man, rejected him. This angered Job. Sometime in September 2003, while Dang and her sister Lynn were on their way home, Job and his minor friend Nonoy grabbed them and pushed them inside a white van. They brought them in an abandoned warehouse where they forced them to dance naked. Thereafter, they brought them to a hill in a nearby barangay where they took turns raping them. After satisfying their lust, Job ordered Noynoy to push Dang down a ravine, resulting in her death. Lynn ran away, but Job and Nonoy chased her and pushed her inside the van. Then the duo drove away. Lynn was never seen again. The corpus delicti or fact of commission of the crime is clear. Even the death of Lynn may be established from the acts of the culprits, without the need of the body of Lynn being presented. The police officer in civilian clothes asked why, where he can buy shabu. X responded by asking the officer how much of the drug he needed. When he told him, X left, returned after a few minutes with the shabu, gave it to the officer, and took his money. X is liable for selling since the police operation was a valid entrapment. X, without intent to kill, aimed his gun at Z and fired it, hitting the latter, who died as a consequence under the circumstances. X cannot plead praeter intentionem since the intent to kill is presumed from the killing of the victim. 2011. Scope of application and characteristics of Philippine criminal law. Ando, an Indonesian national who just visited the Philippines, purchased a ticket for a passenger vessel bound for Hong Kong. While on board the vessel, he saw his mortal enemy Lason, also an Indonesian national, seated at the back portion of the cabin and who was busy reading a newspaper. Ando stealthily approached Lason and when he was near him, stabbed and killed Lason. The vessel is registered in Malaysia. The killing happened just a few moments after the vessel left the port of Manila. Operatives from the PNP Maritime Command arrested Ando, presented for the killing of Lason. Ando contended that he did not incur criminal liability because both he and the victim were Indonesians. He likewise argued that he could not be prosecuted in Manila because the vessel is a Malaysian registered ship. Discuss the merits of Ando's contention, 2015. Both contentions of Ando lacked merit. The argument of Ando that he did not incur criminal liability because both he and the victim were Indonesians is not tenable. Under the generality principle, penal laws shall be obligatory upon all who live or sojourn in the Philippine territory, Article 14 of the Civil Code. The fourth characteristic of an offender, an offended party does not exclude him from operation of penal laws. People versus Galakak. Under the revised penal code, except as provided in treaties and laws of preferential application, penal laws of the Philippines shall have force and effect within its territory. Here, since the killing took place within the Philippine territory, our penal laws applies, and Ando may be held criminally responsible despite his being an Indonesian citizen. Likewise, the contention of Ando that he could not be prosecuted in Manila because the vessel is a Malaysian registered ship is without merit. Under the English rule, which our jurisdiction recognizes and follows, crimes committed aboard a vessel within the territorial waters of a country are triable in the courts of such country, except when crimes merely affect things within the vessel or when they only refer to the internal management thereof. Here, since the crime was committed within the Philippine waters and neither exception applies, Ando may be prosecuted in Manila. Additional answer. Under Section 27 of the Convention of the Law of the Sea, the criminal jurisdiction of the coastal state should not be exercised on board a foreign ship passing through the territorial sea to arrest any person or to conduct any investigation in connection with any crime committed on board the ship during its passage except if the crime is of a kind to disturb the peace of the country or the good order of the territorial sea. The vessel is still within the territorial waters of the Philippines when the crime was committed. Since the killing happened a few moments after the vessel left the port of Manila, murder committed by Ando disturbs the peace of the Philippines. Hence, he could be prosecuted in Manila. Generality, territoriality. Which of the following crimes is an exemption to the territoriality rule in criminal law, 2011? Plunder committed at his place of assignment abroad by a Philippine public officer. When committed outside the Philippine territory, our courts do not have jurisdiction over the crime. Of 2011, rebellion. Pierce is a French diplomat stationed in the Philippines. While on EDSA and driving with an expired license, he hit a pedestrian who was crossing illegally. The pedestrian died. Pierce was charged with reckless imprudence resulting in homicide. In his defense, he claimed diplomatic immunity. Is Pierce correct? 2014. Yes, Pierce is correct. Pierce, being a French diplomat stationed in the Philippines, would be exempt from the general application of our criminal laws, as provided for under laws or treaties of preferential application, more particularly under RA 75. A foreigner residing in Hong Kong counterfeits a 20 peso bill issued by the Philippine government. May the foreigner be prosecuted before a civil court in the Philippines, 2012. Yes, the provisions of the revised penal code are enforceable also outside the jurisdiction of the Philippines against those who should forge or counterfeit currency notes of the Philippines or obligations and securities issued by the government of the Philippines. Prospectivity, effects of repeal, amendment of penal laws. Constitutional limitations, the power of Congress to enact penal laws. Distinguish between ex post facto law and Bill of Attainder, 2015. Ex post facto law is any law which makes an innocent act a crime after the act was committed. It is a Latin phrase which means from something done afterwards. It could also be a law which aggravates a crime, or makes it greater than when it was committed, or which changes the punishment and inflicts a greater penalty than the law governing the crime when committed. A bill of attainder is a law which inflicts punishment on a named individual or a group of individuals without judicial trial. Ex post facto law pertains to the act, while a bill of attainder pertains to a named individual or to member of a group. Congress passed a law reviving the anti-subversion law, making it a criminal offense again for a person to join the Communist Party of the Philippines. Reforma former high-ranking member of the Communist Party, was charged under the new law for his membership in the Communist Party when he was a student in the 1980s. He now challenges the charge against him. What objections may he raise? 2014. Reformer may raise the limitations imposed by the 1987 Constitution on the power of Congress to enact retroactive penal laws which are prejudicial to the accused. Under the Bill of Rights of the Constitution, such is classified as an ex post facto law. It should be noted that when Congress decriminalized the crime of subversion under RA 7637, it obliterated the felony and its effect upon reforma. Consequently, charging him now under the new law for his previous membership in the Communist Party would be constitutionally impermissible. What are the constitutional provisions limiting the power of Congress to enact penal laws? 2012. Suggested answer. The constitutional provisions limiting the power of Congress to enact penal laws are the following. 1. The law must not be an ex post facto law, or it should not be given a retroactive effect. Number 2. The law must not be a bill of attainder, meaning it cannot provide punishment without judicial process. 3. The law must not impose cruel, unusual, or degrading punishment. Number 4. No person shall be held to answer for a criminal offense without due process of law. Equal protection, due process. Assume that you are a member of the legal staff of Senator Salcedo who wants to file a bill about imprisonment of the National Penitentiary in Muntinlupa. He wants to make the state prison a revenue earner for the country through a law providing for premium accommodations for prisoners other than those under maximum security status, whose wives are allowed conjugal weekend visits, and for those who want long-term premium accommodations. For conjugal weekenders, he plans to rent out rooms with hotel-like amenities at rates equivalent to those charged by four-star hotels. For long-term occupants, he is prepared to offer room and board with special meals in air-conditioned, single-occupancy rooms at rates equivalent to those charged by three-star hotels. What advice will you give the senator from the point of view of criminal law, taking into account the purpose of imprisonment, the considerations of ethics and morality? 2013 bar. I would advise Senator Salcedo not to file the said bill. First, the bill is unconstitutional as it violates the Equal Protection Clause of the Constitution. It will create economic inequality in our criminal justice system. Rich prisoners will enjoy better amenities and privileges than those who are poor. Second, the bill will defeat the purpose of penalties in criminal law, which is to secure justice, retribution, and reformation. How are felonies committed? 2015. Felonies are committed not only by means of deceit, dolo, but also by means of fault, culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful acts result from imprudence, negligence, lack of foresight, or lack of skill. Article 3 of Revised Penal Code. Aberratio ictus, error in persona, praeter intentionem. What is aberratio ictus? Aberratio ictus means mistake of blow. Under the principle of aberratio ictus, a person is criminally responsible for committing an intentional felony, although the consequent victim is different from that intended due to mistake of blow. This principle is based on the rule in Article 4 of the Revised Penal Code, which provides that criminal liability shall be incurred by any person committing a felony, delito, although the wrongful act done be different from that which he intended. Felonies are classified according to manner or mode of execution into felonies committed by means of deceit, dolo, or by means of fault, culpa. Which of the following causes may not give rise to culpable felonies? 2012. Malice. The classification of felonies into grave, less grave, and light is important in ascertaining 2011 if certain crimes committed on the same occasion can be complex. Is the penalty for impossible crime applicable to one who attempts to commit a light felony or impossible materialization? 2012. No, the penalty for consummated light felony is less than the penalty for impossible crime. D.O. intending to kill E.E. peppered the latter's bedroom with bullets, but since the intended victim was not home at the time, no harm came to him. What crime is committed? D.O. committed the crime of impossible crime. Inted versus C.A. Can there be a frustrated impossible crime? 2012. No, there can be no frustrated impossible crime because the offender has already performed acts for the execution of the crime. Alternative answer, no, There can be no frustrated impossible crime because the means employed to accomplish the crime is inadequate or ineffectual. Putti detested Pula, his roommate, because Pula was courting Ganda, whom Putti fancied. One day, Putti decided to teach Pula a lesson and went to a veterinarian vet to ask for poison on the pretext that he was going to kill a sick pet, when actually Putti was intending to poison Pula. The vet instantly gave Putti a non-toxic solution, which, when mixed with Pula's food, did not kill Pula. 2014. What crime, if any, did Putti commit? Would your answer be the same if, as a result of the mixture, Pula got an upset stomach and had to be hospitalized for 10 days? Suggested answer. Putti committed the impossible crime of murder. All the elements of an impossible crime are present. Putti's act of mixing a solution with Pula's food would have been murder, a crime against person. The act was done evil intent, which is to kill Pula. However, the crime was not accomplished because of the employment of ineffectual means. The solution turned out to be non-toxic, which would not kill Pula, and said act would not fall under any other provisions of the RPC. No, my answer would not be the same. If, as a result of the mixture, Pula got an upset stomach and had to be hospitalized for 10 days, the crime committed by Putti is less serious physical injuries. It is not an impossible crime because the last element of an impossible requires that the act performed should not constitute a violation of another provision of the RPC. Carla, 4 years old, was kidnapped by Enrique, the tricycle driver, engaged by her parents to drive her to and from school every day. Enrique wrote a ransom note demanding that Carla's parents pay him 500,000 ransom in exchange for her liberty. However, before the ransom note could be received by Carla's parents, Enrique's hideout was discovered by the police. Carla was rescued while Enrique was arrested. The prosecutor considered the ransom note was never received by Carla's parents and filed a case of impossible crime to commit kidnapping against Enrique. Is the prosecutor correct? If he is not correct, can he instead file a case of grave coercion? 2014. The prosecutor is not correct. There is no impossible crime to commit kidnapping. First, an impossible crime applies only to crimes against person and crimes against property under Titles 8 and 10 of the RPC, respectively. Kidnapping is a crime against personal liberty and security under Title 9 RPC. Second, even if the ransom note was not received by Carla's parents, the crime of kidnapping and serious illegal detention for ransom is already consummated. Under Article 267 RPC, kidnapping for ransom is committed when the kidnapping or detention is for the purpose of extorting ransom from the victim or any other person. To consummate the crime, it suffices that the purpose is to extort ransom. It is not necessary that the ransom note be received or that ransom be paid. No, the prosecutor cannot file a case of grave coercion because the crime committed, as explained above, is kidnapping for ransom. Criminal law. Impossible crime of murder. Charlie hated his classmate Brad because the latter was assiduously courting Lily, Charlie's girlfriend. Charlie went to a veterinarian and asked for some poison on the pretext that it would be used to kill a very sick old dog. Actually, Charlie intended to use the poison on Brad. The veterinarian mistakenly gave Charlie a non-toxic powder which, when mixed with Brad's food, did not kill Brad. Did Charlie commit any crime? If so, what and why? If not, why not? Suggested answer. Charlie committed an impossible crime of murder. His act of mixing the non-toxic powder with Brad's food, done with intent to kill, would have constituted murder, which is a crime against person, had it not been for the employment of a means which, unknown to him, is ineffectual. Would your answer be the same if Brad proved to be allergic to the powder and after ingesting it with his food, fell ill and was hospitalized for 10 days? 2009. No, the answer would not be the same. Charlie would be criminally liable for less serious physical injuries because his act of mixing the powder with Brad's food was done with felonious intent and was the proximate cause of Brad's illness for 10 days. It cannot constitute attempted murder, although done with intent to kill, because the means employed is inherently ineffectual to cause death, and the crime committed must be directly linked to the means employed, not to the intent. Liability for an impossible crime can only arise from a consummated act. In an attempted felony, the offender's preparatory act requires another act to result in a felony. 2011. Criminal law stages of execution frustrated murder. Delmo learned that his enemy Oscar was confined at the intensive care unit of the Philippine Medical Center. Intending to kill Oscar, Delmo disguised himself as a nurse, entered the ICU, and saw a man lying on the hospital bed with several life-saving tubes attached to the body. Delmo disconnected the tubes and left. Later, the resident physician, doing his rounds, entered the ICU and, seeing the disconnected tubes, replaced them. The patient survived. It turned out that the patient was Larry, as Oscar had been discharged from the hospital earlier. Delmo was charged with frustrated murder, qualified by evident premeditation and treachery as aggravating circumstances. Discuss the propriety of the charge. 2009. Delmo was correctly charged with the crime of frustrated murder, qualified by treachery, not evident premeditation because the victim was different from the one premeditated against. Delmo has performed all the acts of execution that would produce the death of the victim, but for reasons independent of the will of the perpetrator, the death of the victim was not accomplished. Treachery qualifies the crime because the means, manner, and method of committing the intended killing were consciously adopted to ensure its execution without risk that may arise from the defense the victim may make. Evident premeditation is absorbed in the treachery. Overjoyed by the award to his firm of a multi-billion government contract for the development of an economic and tourism hub in the province of Blanc, Mr. Gangnam allotted the amount of 100 million to serve as gifts for certain persons instrumental in his firm's winning the award. He gave 50% of that amount to Governor Datu, the official who had signed the contract with the proper authorization from the Sangguniang Panlalawigan, 25% to Bokal Diva, the Sangguniang Panlalawigan member who had lobbied for the award of the project in the Sangguniang Panlalawigan, and 5% to Mayor Dolor of the municipality where the project would be implemented. Governor Datu received his share through his wife, Provincial First Lady D, who then deposited the amount in her personal bank account. Previously, upon facilitation by Bokal Diva, Mr. Gangnam concluded an agreement with Mayor Dolor for the construction of the Blanc Sports Arena worth 800 million. The project was highly overpriced because it could be undertaken and completed for not more than 400 million. For this project, Mayor Dolor received from Mr. Gangnam a gift of 10 million, while Bokal Diva got 25 million. In both instances, Bokal Diva had her monetary gifts deposited in the name of her secretary, Terry, who personally maintained a bank account for Bokal Diva's share in the government projects. Define will conspiracy and chain conspiracy. Is either or both kinds existent herein? Explain your answer. In the case at bar, both type of conspiracy exists: the distribution of commissions or gifts by Mr. Gangnam and acceptance of Governor Tatu, Bokal Diva, Mayor Dolor is a type of will conspiracy where a single person, Mr. Gangnam, dealt individually with the public officials to commit the overt acts. The chain conspiracy, on the other hand, is evident in the overpricing of the sports complex through the facilitation of Bokal Diva, the conclusion of the agreements by Mayor Dolor, and the distribution of the gift by Mr. Gangnam. Alternative answer: there are two structures of multiple conspiracies, namely will or circle conspiracy and chain conspiracy. Under the will or circle conspiracy, there is a single person or group, the hub, dealing individually with two or more other persons or groups, the spokes. Fernan Jr. versus People, GR 145927. In will conspiracy involving plunder, the hub or the principal plunder amasses, accumulates, and acquires ill-gotten wealth in connivance with other or spokes. In plunder, the hub or principal plunder must be a public officer, GMA versus People, GR 220598, but the spokes can be a private individual, Enrile versus People, GR 213455. In this case, there is no will conspiracy involving plunder. Mr. Gangnam cannot be considered as a hub since he is not a public officer. Under the chain conspiracy, usually involving the distribution of narcotics or other contraband, in which there is successive communication and cooperation in much the same way as with legitimate business operations between manufacturer and wholesaler, then wholesaler and retailer, and then retailer and consumer. Vernon versus People, GR 14597. There's a chain conspiracy involving plunder in this case. Vocal Diva conspired with Mr. Gangnam in committing plunder, and then he conspired with Mr. Gangnam in committing plunder, and then he conspired with Terry, his secretary, in hiding all his ill-gotten wealth by depositing the proceeds of plunder under the account of the latter. Because of the chain conspiracy, Vocal Diva, Mr. Gangnam, and Terry are liable for plunder. Under RA 7080, any person who participated with the said public officer in the commission of an offense contributing to the crime of plunder shall likewise be punished for such offense. Proposal to commit felony is punishable only in cases in which the law specifically provides a penalty therefor. Under which of the following instances are proponents not liable? 2012. Proposal to commit sedition. A proposal to commit a felony is punishable only when law specifically provides a penalty for it, as in the case of proposal to commit rebellion. Conspiracy to commit felony is punishable only in cases in which the law specifically provides a penalty therefor. Under which of the following instances are the conspirators not liable? Conspiracy to commit trafficking in persons. Define conspiracy. Conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Distinguished by law. Of illustration, conspiracy as a felony from conspiracy as a manner of incurring liability in relation to the crimes of rebellion and murder, 2012. Conspiracy to commit rebellion. If A and B conspire to overthrow the government, conspiracy is punishable. Conspiracy to commit rebellion is a felony. Rebellion. If they committed rebellion, they are equally liable for the crime of rebellion. However, they will not be additionally charged with conspiracy to commit rebellion, since they committed what they conspired. Conspiracy will not be considered as an independent felony, but as a manner of incurring criminal responsibility. Conspiracy to commit homicide, not punishable. If A and B conspire to kill X, conspiracy is not punishable. The law provides no penalty for conspiracy to commit homicide. Homicide is if, pursuant to conspiracy to commit homicide, A embraced X and then B stabbed and killed X. The conspirators are equally liable for homicide. Conspirators are equally liable for homicide. Conspiracy, in this case, will be considered as a manner of incurring liability. Conspiracy to commit felony is punishable only in cases where the law specifically provides a penalty. Which of the following combinations contains specific felonies under the Revised Penal Code, 2013? Conspiracy to commit rebellion, conspiracy to commit coup d'etat, conspiracy to commit treason, conspiracy to commit sedition. Define malfeasance, misfeasance, and nonfeasance. Differentiate with conspiracy and chain conspiracy, 2016 bar. Malfeasance is the doing of an act which a person ought not to do at all. Misfeasance is the improper doing of an act which a person might lawfully do. Nonfeasance is the omission of an act which a person ought to do. Black Laws Dictionary, 6th edition. There are two structures of multiple conspiracies, namely wheel or circle conspiracy and chain conspiracy. Wheel conspiracy occurs when there is a single person or group, the hub, dealing individually with two or more other persons or groups, the spokes. The spoke typically interacts with the hub rather than with another spoke. In the event that the spoke shares a common purpose to succeed, there is a single conspiracy. However, in the instances when each spoke is unconcerned with the success of the other spokes, there are multiple conspiracies. A chain conspiracy, on the other hand, exists when there is successive communication and cooperation in much and same way as with legitimate business operations between manufacturer and wholesaler, then wholesaler and retailer, and then the retailer and consumer. Estrada versus Sandigambay. Who is a habitual delinquent? Distinguish habitual delinquency from recidivism as to the crimes committed, the period of time the crimes are committed, the number of crimes committed, and their effects in relation to the penalty to be imposed on a convict, 2012. A person shall be deemed to be habitual delinquent if within a period of 10 years from the date of his release or last conviction of the crimes of serious or less serious physical injuries, robo, hurto, estafa, or falsification, he is found guilty of any of said crimes a third time, oftener. The following are the differences between recidivism and habitual delinquency. Nature of crime, recidivism, first crime and the aggravated second crime are embraced in the same title of the RPC. Time element, accused was convicted of the first crime by final judgment at the time of the trial of the second crime. Number of crimes, at least 2 crimes committed. Nature of the aggravating circumstances. Ordinary aggravating circumstances, the presence of any of which will trigger the application of the penalty for the second crime committed in its maximum period unless it is offset by a mitigating circumstance. Habitual delinquency, nature of crime. First, second, and third crimes must be a habitual delinquency crime, that is, serious or less serious physical injuries, theft, robbery, estafa, falsification of document. Time element. The accused was convicted at first habitual delinquency crime. Within 10 years after conviction or release, he was found guilty. Habitual delinquency crime for the second time. Within 10 years after conviction or release, he was found guilty of habitual delinquency crime for the third time or oftener. Number of crimes, at least 3 crimes committed. Nature of the aggravating circumstances, extraordinary or special aggravating circumstance, the presence of which will trigger the imposition of additional penalty for the third or subsequent crime. This is not subject to offset rule. During trial for theft in 2014, the prosecution managed to show that accused AA has also been convicted by final judgment for robbery in 2003, but she eluded capture. A subsequent verification showed that AA had several convictions, to wit. In 1998, she was convicted of estafa. In 2002, she was convicted of theft. In 2004, she was convicted of frustrated homicide. The judge trying the theft case in 2014 is about to convict AA. What circumstances affecting the liability or penalty the judge appreciate against AA 2014? The judge may appreciate the aggravating circumstance of recidivism. A recidivist is one who, at the time of his trial or for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of the RPC. Robbery, theft, estafa are crimes against property embraced in the Title 10 of the RPC. The judge may also appreciate the aggravating circumstance of habituality or reiteration because there have been 2 or more crimes committed for which she has been published, regardless of the degree of penalty. Amado, convicted of rape but granted an absolute pardon by the President and 1 year thereafter convicted of homicide, is a recidivist. True or false? True. Rape is now a crime against person, and like the crime of homicide, is embraced in the same title of the revised Penal Code, under which Amado had been previously convicted by final judgment. The absolute pardon granted him for rape only excused him from serving the sentence of rape but did not erase the effects of the conviction, therefore unless expressly remitted by the pardon. B was convicted by final judgment of theft. While serving sentence for such offense, B was found in possession of an unlicensed firearm. Is B a quasi-recidivist? 2012. B is not a quasi-recidivist because the second offense is not a felony. Alternative answer. B is a quasi-recidivist because he was serving sentence when found in possession of an unlicensed firearm. Angelo devised a Ponzi scheme in which 500 persons were deceived into investing their money upon a promise of a capital return of 25%, computed monthly, and guaranteed by post-dated checks. During the first 2 months following the investment, the investors received their profits, but thereafter, Angelo vanished. Angelo was charged with 500 counts of estafa and 2,000 counts of violation of Batas Pambansa. In his motion to quash, Angelo contends that he committed a continued crime or delicto continuado. Hence, he committed only 1 count of estafa and 1 count of violation of BP 22. What is delito continuado? 2009. Delito continuado refers to a crime constituted by several overt acts committed by the offender in one place at about the same time, and all such overt acts violate one and the same provisions of penal law, thus demonstrating that all such acts are the product of a single indivisible criminal resolution. Hence, all said acts are considered one crime only. Is Angelo's contention tenable? 2009. No, his contention is not tenable. He committed as many counts of estafa against the 500 victims and 2,000 counts of violation of BP 22. Since each swindling is achieved through distinct fraudulent machinations, contrived at different times or dates, and in different amounts. Moreover, his drawing separate checks payable to each payee is a separate criminal resolution, as they must be of different amounts and of different dates. He acted with separate fraudulent intent against each swindling victim and had distinct criminal intent in drawing and issuing each check. It cannot be maintained that his acts are the product of one criminal resolution only. Alternative answer, yes. Angelo committed only one count of estafa and one count of violation of BP 22 because his acts were propelled by one and the same intent to defraud. Santiago versus Garchi-Torena. Pedro, Pablito, Juan, and Julio, all armed with bolos, robbed the house where Antonio, his wife, and 3 daughters were residing. While the 4 were ransacking Antonio's house, Julio noticed that one of Antonio's daughters was trying to escape. He chased and caught up with her at the tiquest somewhat distant from the house, but before bringing her back, raped her. What or crimes, if any, did Pedro, Pablito, Juan, and Julio commit? Explain. B. Suppose after the robbery, the 4 took turns in raping the 3 daughters inside the house, and to prevent identification, killed the whole family just before they left. What crime or crimes, if any, did the 4 malefactors commit? 2016. Julio is liable for a special complex crime of robbery with rape, since he raped the daughter of Antonio on occasion or by reason of robbery. Even if the place of robbery is different from that of rape, the victim is still robbery with rape, since what is important is the direct connection between the 2 crimes. People versus Canastra. Rape was not separate by distance and time from the robbery. Pedro, Pablito, and Juan are liable for robbery by band. There is band in this case since more than 3 armed malefactors take part in the commission of a robbery. Under Article 296 of the Revised Penal Code, any member of a band who is present at the commission of a robbery by the band shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. The assault mentioned in Article 296 includes rape. People versus Hamiana. They are liable, however, for rape under Article 296 since they were not present when the victim was raped and thus they had no opportunity to prevent the same. They are only liable for robbery by band. People versus Anticamaray. B. They are liable for a special complex crime of robbery with homicide. In this special complex crime, it is immaterial that several persons are killed. It is also immaterial that aside from the homicide, rapes are committed by reason or on the occasion of the crime. Since homicides are committed by or on the occasion of the robbery, the multiple rapes shall be integrated into one and indivisible felony of robbery with homicide. OFW worked in Kuwait for several years as a chief accountant, religiously sending to his wife B 80% of all his earnings. After his stint abroad, he was shocked to know that B became the paramour of a married man, C, and that all the monies he sent to B were given to her to C. To avenge his honor, A hired X, Y, and Z and told them to kidnap C and his wife, D, so that he can inflict injuries on C to make him suffer and humiliate him in front of his wife. X, Y, and Z were paid 20,000 each and were promised to reward of 50,000 each once the job is done. At midnight, A, with a fully armed X, Y, and Z, forcibly opened the door and gained entrance to the house of C and D. C put up a struggle before he was subdued by A's group. They boarded C and D in a van and brought the 2 to a small hut in a farm outside Metro Manila. Both hands of C and D were tied. With the help of X, Y, and Z, A raped D in front of C. X, Y, and Z then took turns in raping D and subjected C to torture until he was black and blue and bleeding profusely from several stab wounds. A and his group set the hut on fire before leaving. killing both C and D. X, C, and Y were paid the reward. Bothered by his conscience, A surrendered the next day to the police, admitting the crimes he committed. As the RTC judge decide what crime or crimes were committed by A, X, Y, and Z, and what mitigating and aggravating circumstances will be applied in imposing the penalty. A, X, Y, and Z are liable for 2 counts of kidnapping with murder qualified by means of fire, since C and D were killed in the course of the detention. In a special complex crime of kidnapping with murder, it is immaterial that other crimes were committed, such as multiple rapes and arson. Since multiple rapes and arson are committed by reason of or on occasion of kidnapping, they shall be integrated into one and indivisible felony of kidnapping with murder. People versus Laranaga. The mitigating circumstances of passion and voluntary surrender can be appreciated in favor of A. The aggravating circumstances of unlawful entry by means of fire and treachery can be appreciated against A, X, Y, and Z. A police officer surreptitiously placed a marijuana stick in a student's pocket and then arrested him for possession of marijuana cigarette. What crime can the police officer be charged with? Complex crime of incriminating an innocent person with unlawful arrest. A special complex crime is a composite crime, 2011, with its own definition and special penalty provided by the Penal Code. X intending to kill Y, a store owner fired at Y from the street, but the shot killed not only Y but also Z, who was in the store. As a case of aberratio ictus, it is punishable as a 2011 compound crime. Wenceslao and Loretta were staying in the same boarding house, occupying different rooms. One late evening, when everyone in the house was asleep, Wenceslao entered Loretta's room with the use of a picklock. Then with force and violence, Wenceslao ravished Loretta. After he had satisfied his lust, Wenceslao stabbed Loretta to death and before leaving the room, took her jewelry. What crime or crimes, if any, did Wenceslao commit? 2009. Wenceslao committed the following crimes: the special complex crime of rape with homicide, theft, and unlawful possession of picklocks and similar tools under Article 304 RPC. His act of having carnal knowledge of Loretta against her will and with the use of force and violence constituted rape, plus the killing of Loretta by reason or on the occasion of the rape, gave rise to the special complex crime of rape with homicide. Since the taking of the jewelry was an afterthought, and it was done only when he was about to leave the room and when Loretta was already dead, the same constitutes theft. His possession and use of picklock without lawful cause is by itself punishable under Article 304 RPC. Would your answer be the same if, despite the serious stab wounds she sustained, Loretta survived? 2009. No, the answer will be different. In that case, the crimes committed would be 4 separate crimes: rape, frustrated homicide or murder, theft, and unlawful possession of use of picklocks under Article 304 RPC. The special complex crime of rape with homicide is constituted only when both the rape and the killing are consummated. When one or both of them are not consummated, they are to be charged and punished separately. In any event, the possession of the picklock without lawful cause, more so its use in an lawful entry, is punished as a crime by itself. Roger and Jesse, municipal mayor and treasurer, respectively, of San Rafael Leyte, caused the disbursement of public funds allocated for their local development programs for 2008. Records show that amount of $2 million was purportedly used as financial assistance for a rice production livelihood project. Upon investigation, however, it was found that Roger and Jesse falsified disbursement vouchers and supporting documents in order to make it appear that qualified recipients, who in fact are non-existent individuals, received the money. Roger and Jesse are charged with malversation through falsification. Discuss the proprietary of the charge filed against Roger and Jesse. 2009. The charge of malversation through falsification is not correct because the falsification of several documents were not necessary means to obtain the money that were malversed. The falsification were committed to cover up or hide the malversation and therefore should be separately treated from malversation. The given facts state that Roger and Jesse falsified disbursement vouchers and supporting documents in order to make it appear that qualified recipients received the money. Article 48 RPC on complex crime is not applicable. While Alfredo, Braulio, Ciriaco, and Domingo were robbing a bank, policemen arrived. A firefight ensued between the bank robbers and the responding policemen, and one of the policemen was killed. What crime or crimes, if any, had been committed? 2009. The crimes committed are robbery with homicide, a single indivisible offense, and direct assault with multiple attempted homicide, a complex crime. Article 48, Article 148, and Article 249 RPC People v. Gairama. Robbery with homicide was committed because one of the responding policemen was killed by reason or on occasion of the robbery being committed. The complex crime of direct assault with multiple attempted homicide was committed in respect of the offenders firing guns at the responding policemen, who are agents of persons in authority, performing their duty when fired at to frustrate such performance. People v. Ladjaalam. Suppose it was Alfredo who was killed by the responding policeman. What charges can be filed against Braulio, Ciriaco, and Domingo? The crime of which Braulio, Ciriaco, and Domingo can be charged is robbery with homicide, because the killing resulted by reason or on the occasion of the robbery. It is of no moment that the person killed is one of the robbers. A killing by reason or on the occasion of robbery, whether deliberate or accidental, will be a component of the crime of robbery with homicide, a single indivisible offense, as long as it is intimately connected to the robbery. Suppose in the course of the robbery, before the policeman arrived, Braulio shot and killed Alfredo following a heated disagreement on who should carry the money bags. What would be the criminal liability of Braulio, Ciriaco, and Domingo? 2009. Braulio shall be liable for robbery with homicide for killing Alfredo, since the killing was by reason of the robbery. Ciriaco and Domingo, having conspired only in the commission of the robbery, should incur liability only for the crime conspired upon, the robbery, unless they were with Braulio during the killing and could have prevented the same, but they did not, in which case they shall also be liable for robbery with homicide. It is of no moment that the person killed is one of the robbers, and he was killed during the robbery. People v. Barot. Christopher, John, Richard, and Luke are fraternity brothers. To protect themselves from rival fraternities, they all carry guns wherever they go. One night, after attending a party, they boarded a taxicab, held the driver at gunpoint, and took the latter's earning. What crime, if any, did the four commit if they killed the driver? 2010. The crime becomes robbery with homicide, and all the fraternity brothers are liable. The existence of a ban shall be appreciated only as generic aggravating circumstance. Also, if the firearms used were unlicensed, the same would only be taken as generic aggravating circumstance, as provided by the Republic Act No. 8294, People v. Bullinget. The alternative circumstance of relationship shall not be considered between aunt and nephew. Okay. As a modifying circumstance, insanity is in the nature of confession and avoidance. A qualifying aggravating circumstance changes the description and the nature of the offense. 2011. What is the nature of the circumstance which is involved in the imposition of maximum term of the indeterminate sentence? 2012. Modifying circumstance. Porthos made a sudden turn on a dark street, and his Rolls-Royce SUV bumped the rear of a parked Cadillac sedan, inside which Aramis was then taking a nap. Angered by the violent impact, Aramis alighted and confronted Porthos, who had also alighted. Aramis angrily and repeatedly shouted at Porthos, "Putang ina mo," Porthos, displaying fearlessness, aggressively shouted back at Aramis, "Huwag kang magtatapang-tapangan dyan, papatayin kita." Without saying anything more, Aramis drew his gun from his waist and shot Porthos in the leg. Porthos' wound was not life-threatening. What are the kinds of unlawful aggression, and which kind was displayed in this case? Standing trial for frustrated murder, Aramis pleaded self-defense. The prosecutor's contention was that the plea of self-defense applied only to consummated killings. Rule with explanations on the tenability of Aramis' claim of self-defense and on the prosecution's contention. See Porthos insisted that the element of treachery was present. To rule out treachery, Aramis asserted that both he and Porthos were then facing and confronting each other when he fired the shot. Rule with reasons on the respective contentions, 2017. Answer to letter A. Unlawful aggression is of two kinds, actual or material unlawful aggression, and B. Imminent unlawful aggression. Actual or material unlawful aggression means an attack with physical force or with a weapon, an offensive act that positively determines the intent of the aggressor to cause the injury. Imminent unlawful aggression means an attack that is impending or at the point of happening. It must not consist in a mere threatening attitude, nor must it be merely imaginary, but must be offensive and positively strong, like aiming a revolver at another with intent to shoot, or opening a knife and making a motion as if to attack. Imminent unlawful aggression must not be a mere threatening attitude of the victim, such as pressing his right hand to his hip where a revolver was holstered, accompanied by an angry countenance, or like aiming to throw a pot, Rustia versus People. In this case, there is neither actual or imminent unlawful aggression. The statement papatayin kita neither constitute an attack with physical force or with a weapon, an offensive act that positively determines the intent of the aggressor to cause the injury, nor an impending attack which is offensive and positively strong. Answer to letter B. The prosecution's contention is not tenable. Shooting the leg of the victim without killing him may be a reasonable means to prevent or repel an actual or imminent unlawful aggression. Hence, self-defense is not confined to consummated killing. Letter C. There is no treachery, as the attack was preceded by heated words. The act was spontaneous, arising from the said circumstance. The sudden attack was not preconceived and deliberately adopted, but was just triggered by the sudden infuriation of the part of the accused because of the provocative act of the victim, where their meeting was purely accidental. Three men gave Arnold fist blows and kicks, causing him to fall. As they surrounded and continued hitting him, he grabbed a knife he had in his pocket and stabbed one of the men straight to the heart. What crime did Arnold commit? No crime, since he needed to repel the aggression, employing reasonable means for doing so. To save himself from crashing into an unlighted truck abandoned on the road, Jose swerved his car to the right towards the graveled shoulder, killing two bystanders. Is he entitled to the justifying circumstance of state of necessity, 2011? Yes, since the instinct of self-preservation takes priority in an emergency. Under which of the following circumstances is an accused not liable for the result not intended, 2012? Accused is not criminally liable for the result not intended when there is mistake of fact constituting an involuntary act. Alternative answer. Accused is not criminally liable for the result not intended when the wrongful act is not the proximate cause of the resulting injury. Pedro is married to Tessie. Juan is the first cousin of Tessie. While in the market, Pedro saw a man stabbing Juan. Seeing the attack on Juan, Pedro picked up a spade nearby and hit the attacker on his head, which caused the latter's death. Can Pedro be absolved of the killing of the ground that it is in defense of a relative? 2016. No. The relatives of the accused for purposes of defense of relative under Article 11, Number 2 of the Revised Penal Code are his spouse, ascendants, descendants, or legitimate natural or adopted brothers or sisters, or of his relatives by affinity in the same degree, and those by consanguinity within the fourth civil decree. Relative by affinity within the same degree includes the ascendant, descendant, brother or sister of the spouse of the accused. In this case, one is not the ascendant, descendant, brother or sister of Tessie. The spouse of Pedro, relative by consanguinity within the fourth civil decree, includes first cousin, but in this case, one is the cousin of Pedro by affinity, but not by consanguinity. One therefore is not a relative of Pedro for purpose of applying the provision on defense of relative. Pedro, however, can invoke defense of a stranger. Under the Revised Penal Code, a person who defends a person who is not his relative may invoke the defense of a stranger, provided that all its elements exist to it: unlawful aggression, reasonable necessity of the means employed to prevent or repel the attack, and C. The person defending be not induced by revenge, resentment, or other evil motive. Romeo and Julia have been married for 12 years and had 2 children. The first few years of their marriage went along smoothly. However, on the 5th year onwards, they would often quarrel when Romeo comes home drunk. The quarrels became increasingly violent, marked by quiet periods when Julia would leave the conjugal dwelling. During these times of quiet, Romeo would court Julia with flowers and chocolate and convince her to return home, telling her that he could not live without her, or Romeo would ask Julia to forgive him, which she did, believing that it is she humbled herself. Romeo would change. After a month of marital bliss, Romeo would return to his drinking habit, and the quarrel would start again, verbally at first, until it would escalate to physical violence. One night, Romeo came home drunk and went straight to bed. Fearing the onset of another violent fight, Julia stabbed Romeo while he was asleep. A week later, their neighbors discovered Romeo's rotting corpse on the marital bed. Julia and the children were nowhere to be found. Julia was charged with parricide. She asserted battered woman syndrome as her defense. Explain the cycle of violence. Is Julia's battered woman syndrome defense meritorious? Answer. The battered woman syndrome is characterized by the so-called cycle of violence, which has 3 phases: the tension-building phase, the acute battering incident, and the tranquil, loving, or at least nonviolent phase. During the tension-building phase, minor battering occurs. It could be verbal or slight physical abuse or another form of hostile behavior. The woman tries to pacify the batterer through a kind, nurturing behavior or by simply staying out of his way. The acute battering incident is characterized by brutality, destructiveness, and sometimes death. The battered woman deems this incident as unpredictable yet also inevitable. During this phase, she has no control. Only the batterer may put an end to the violence. The final phase of the cycle of violence begins when the acute battering incident ends. During this tranquil period, the couple experience profound relief. Answer to B. Yes. Under Section 3, RA 9262, Battered Woman Syndrome refers to a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationship as a result of cumulative abuse. Under Section 3, letter B, battery refers to an act of inflicting physical harm upon the woman or her child resulting in physical and psychological or emotional distress. In sum, the defense of battered woman syndrome can be invoked if the woman in marital relationship with the victim is subjected to cumulative abuse or battery involving the infliction of physical harm resulting to the physical and psychological or emotional distress. Cumulative means resulting from successive addition. In sum, there must be at least 2 battering episodes between the accused and her intimate partner, and such final episode produced in the battered person's mind an actual fear of an imminent harm from her batterer and an honest belief that she needed to use force in order to save her life. People versus Genosa. In this case, because of the battering episodes, Julia feared the onset of another violent fight and honestly believed the need to defend herself even if Romeo had not commenced an unlawful aggression. Even in the absence of unlawful aggression, however, battered woman syndrome is a defense. Under Section 27 of RA 9262, battered woman syndrome is a defense notwithstanding the absence of any of the elements for justifying circumstances of self-defense under the revised penal code, such as unlawful aggression.